Indie housing market. Get the latest insights right here.
Welcome back to Indie Housing Market. I'm Kyle Morris with Morris Property Group and FC Tucker.
I'm Shelly Walters with the Shelly Walters Realty Group and FC Tucker as well. And today we have an awesome guest that I met through my own HOA, Kelly Elmore, and she is the HOA law help. Tell us what exactly you do. That would be more helpful than me saying it.
So we specialize in the representation of homeowner associations, condominium associations, and other community associations. So any association needs, whether it's reviewing your declaration to provide an opinion on who's responsible for what, amendments to your declaration, covenant violations, collections, pretty much anything related to HOAs and condos.
So was she coming after you because you want to put a pink
we're
pony
turning
in the
over.
front
We're
front
turning
yard?
over to the homeowners from the
from that
builder,
con-
and she's stepping into a little bit of a hornet's nest. But
Which I
that's
see
okay.
that usually happens around year 2 or certain percentages filled. That's got to be a nightmare.
It can be a little complicated, navigating the transition from the developer control over to the homeowner controlled board. So that's usually where we step in to really try to help them go through the contracts, look at the financials, help as they prepare a budget, things like that.
Do you see a lot of covenant changes at that time frame where they're like, let's slip this in here, let's remove that one?
That did happen.
We do.
Before
I've stirred up a
Yeah,
hornet's nest.
before we need the 75% approval.
Yes.
Let's do it now.
Yeah, so what we see quite a bit of is when the homeowners review the governing documents, there are a lot of provisions in declarations that are very developer friendly or put there for developers' needs. And what I always tell owners is you have to remember the mindset. A developer is in the business of building homes and making a profit, so they're setting up an association with that goal in mind. When the owners take over, they're now going to govern and administer the property for years and years, and so the goals are a little bit different.
It's I've ran into a bunch of stuff like even like our HOA is really, really good at the neighborhood I live in, but there's just always stuff that's just not in there. And I think that's what's interesting about being in real estate. And we'll go into the do's and don'ts of like what agents have to do. There's just stuff that is just not covered, right? Like you just can't think of. And so when we were talking about the covenants and restrictions are either insanely vague or insanely specific,
Yes.
right? And like I have one, like I do Christmas lights at the front of our neighborhood every single year. And I pay for them, and I want to do.
You're such a good guy.
Yeah, sure. Anyways, well, it's been a big pain in my ass because like the past 2 years, like turns out rabbits like to eat electrical cords because they're warm. And so people be like, the lights are off, and I'm like, I'm on it. Like I don't have time to go handle the rabbits. But like there's another section that doesn't have a GFCI for me to run lights on the 2 different islands that have all these trees in them. And so like I'm trying to be like, hey guys, I'll pay for this stupid GFCI. Like, how do I make this happen? And like, it was such a headache. I was like, okay, I'm just good.
So how does to do with the HOA? What'd they do to you? Or
they didn't do anything. Or here's another thing. So the light people, I called them out and they're like, everything's fine. So then I have to contact the HOA because the light people are like, we think it's a bad GFCI. And I'm like, I've got an electrician. I'll send them out. And they're like, well, we have to do. And I'm like, guys, like I deal with real estate and repairs every single day. Like I try to be nice and like not step up. Like I could just fix it and take care of it, but it's just like it's a whole process to get a GFCI repaired. And then like you're calling a management company to do it, and then like they have been very responsive, so it's very, very nice. But like I could just go fix this thing, but I'm not allowed to go fix like a $5 switch, and like that can be really, really frustrating to have to deal with that. Or like most neighborhoods these days have like a Facebook page, like a private page, which I try to stay off of. And like we had a tornado. I don't know if anybody knows, we had a tornado here, right? And like we had fencing taken down around our pool, and like right now there's like 2x4s propping the fence up, and they're like, why isn't this fixed? I'm like, oh my God, because it's a process for the HOA, and neighbors are out here all pissed, and I'm just like, I get it,
and
but
you're
like
here
you don't
to
know the
just like,
process.
make sure that these all get taken care of, because the HOA is supposedly the one that can govern what the houses are supposed to look like, how they're supposed to be taken care of, who's supposed to do what. But getting into that kind of a conversation would entail sometimes fines.
Yes.
And I have heard that an HOA cannot really fine, or it's a hard time. So can you go through the process of what a HOA can really do with a homeowner who may be violating? And then I know we get them when we buy, but if I backtrack just a little bit, when we're buying a resale property, I know when they're new, you get it from the builder. Getting the proper covenants is extremely difficult. So that's the second question. The first one would be how fines do actually work,
Sure.
because I could just keep saying I won't do it, right?
Sure. Well, the interesting aspect about fines, particularly in central Indiana, it has been an evolving issue over the last several years. For a long time, there was this sort of belief that just kind of got perpetuated that you can't fine in Indiana. And when I first started practicing in Indiana after practicing in another jurisdiction for years, I thought, well, this is kind of crazy. A lot of the governing documents have the fine language. I'm not sure why people aren't enforcing their own governing documents. And that led us to look at a case from 1987. It was an Indiana appellate court case. And in that case, based on those facts, a court said that what the board had done by imposing a daily fine was impermissible. Now, if you look at the court's reasoning, there were really specific things I think the court took issue with. The board had not adopted a schedule of fines. They sort of just randomly came up with the fine amount. It didn't seem like there was a lot of thought that had gone into. They were imposing it as a daily fine.
That's insane.
Yeah, and I think that the notices, were not probably as great as they could be, and now we have an Indiana grievance process that we follow. So as we dug into that case and then started looking at some of the case law that spun off, our perspective was, well, I understand why the court said over 40 years ago, it's not permissible in that case, but we don't interpret that to apply to every single association, especially when you go through the proper mechanism. So,
which makes sense, because they're even just explaining that, I'm like, you can't do that. You can't do daily fines. You have to have proper notification, how many warnings were given, or what chance were they given to remedy it. Like
Absolutely.
all of that comes into play.
And the due process to owners. So now associations, as long as you have the language in your governing documents, that a lot of times we talked earlier about, sometimes things can be disguised in declarations because you have different attorneys writing declarations. So sometimes you'll see language that says fine. Sometimes it will say a sanction or assessment, a violation assessment. All of it, it's the same thing. It's a fine. So what we do is we work with associations to create a schedule of fines. So there's a specific dollar amount for each violation. It gets distributed to the ownership so everyone knows, hey, if I park my RV in the driveway overnight, that's going to be a $50 fine. Or if I leave my trash cans out, that's a $15 fine. The boards properly adopt it, and then we make sure they give proper notice. And the notices that we send let the owners know, hey, you're actually going to be responsible for a fine if you don't come into compliance. And that's the proper way to do it.
And is that, though, part of the newer covenants? Because older ones may not have ever been ratified or changed. So how do we bring all of them up to today's thoughts on fines?
Some of the older ones do have that language, but we are recommending to associations, especially if you don't have the language, we do an amendment to the declaration. And I know sometimes that's frustrating to boards or to owners because it is that supermajority percentage, whether it's 67% or 75%, depending on your association. But it certainly can be done. We have a lot of associations who are just frustrated by the lack of ability to enforce governing documents. And it's a lot cheaper to assess a reasonable fine to get compliance than it is to go to litigation. Because right now, we're forced, after we send a couple of grievance letters, if an owner doesn't comply, the only way to enforce is to go to litigation. And that's, a silly waste of the court's time. It's a waste of attorney time. So we really like to help associations enforce their governing documents without having to go to court.
So do you see homeowners that are willing to just say, you know what, I'll go to court with you? Because I don't agree with what you want me to do. Like, they're that willing to say, no, I won't move my RV.
I always say, for years, I've always said I am blown away by the number of people who seem to want to pay attorney's fees. So we have filed suit against people. I think in one case we sent between our office and the management company 27 notices about all of the violations. I had a case a couple years ago with an owner who kept parking a trailer and an RV in the parking or the driveway, and then claimed it was a prayer temple. And I think what sometimes owners don't understand is the back and forth and the fighting and the refusing to comply. That's what makes the cases expensive. When we just send a couple of letters, and even if you just file a lawsuit, that's not that expensive. But it's the fighting and the
but people want to fight. It's become this weird thing in the past. Like, I don't know, it's been going on for a while, but ever since COVID, especially, there has been this animosity about HOAs, right? Like, I help so many people who are like, I just want out of an HOA. I mean,
that's a big thing. Buyers
I've lived with
will
good
say
HOAs. I've lived with bad HOAs. The thing is the people who run the HOAs make it good or bad. Exactly. And like, it's also a very thankless and unpaid position. I've done it myself. I'll never do it again. And it's hard. And you do have people who go on a path. It's like anything else. Like, there's good and bad everywhere. And you have people who like want to be assholes, right? Like even the trash can one, right? So then we built these things that now cover them, right? Like that's like it doesn't even like that actually technically shouldn't fly usually.
It's a shed, right?
Which isn't approved either, right? The reality is like we just didn't build houses right for a handful of years, and like you get one car in your 2-car garage. Like that's the reality of it, you know? And then on top of that, we have more waste these days, and trash cans are bigger and they're more durable and all this other stuff. And it sucks.
You got to put those Amazon packages, you know.
Right. And like, I just think it's really interesting how it has, I mean, just like with everything in this society right now, it's like everybody's fighting about everything when they could just be like, you know, mow your grass, you know, like you can't tell me to mow my grass. Like, don't live in a neighborhood where I can tell you to mow your freaking grass.
Well,
you know?
and I think too, though, is it just seems like most people think, well, you know, I'll sit here and wait because sooner or later you'll quit coming after me, or you don't make the guy next door to me do it. Like, there's all this, like, well, if you've got 200 houses in the neighborhood and nobody's, really enforcing it, or it hasn't been enforced, it's awfully hard to start.
It is, and we do council boards. We've had, every so often you'll have a board turnover change. It goes from a completely different owner board to a new board. And they'll come to us and say, all right, the old board was not following the governing documents. They weren't enforcing. What's the best way to approach this? And I think we have seen a lot of success as we've advised associations. Tell the community exactly what you just told us. Hey, for years, unfortunately, the community kind of went downhill because the board wasn't enforcing things. Sheds popped up, grasses, got too high, things like that. But we want to let everybody know there's a new board. We are going to be enforcing the governing documents, and give everyone give a specific date. Everyone has until June 1st to come into compliance. You know what your violations are. By the way, here's a list of the top 5 violations we're seeing right now. We're giving everyone, here's your last free pass. And then you're putting the community on notice. You're fronting the issue that the prior board wasn't enforcing. And most governing documents have a non-waiver clause, meaning just because a board in the past didn't enforce something doesn't mean they can't going forward.
Yeah.
I see that's it, and it's hard too because a lot of times the former board still lives there, right? And you got Bob who is older and started to get dementia, and we all love Bob or whatever. Like, it's just really, really weird. I mean, what do you think the goal of an HOA is? Like, from where I sit, the goal of an HOA is to protect your property values, not your rights.
Absolutely.
Right.
And I always say it's kind of like, if you don't want to adhere to the rules, you don't have to live in an HOA. You don't have to live in a condo. It's
a choice. People don't realize where they're living, even though they own it. That was still a decision and a choice that they made, and they can make another choice.
Exactly.
And we talk about the purchase agreement, and we have to get the HOA documents within, we usually say 3 to 5 days. By the time you're getting ready to make an offer, you should have them either with the listing or given to you before 3 to 5 days are up, so you can make a decision if you want to live there. Getting a hold of them is extremely difficult as real estate agents. For me, if I have
especially
a listing, updated is the hardest part.
You don't even know.
You don't know if there was anything, and it's like there's no really place to go. Like, there's no central housing that says that, okay, these are, I mean, we know Chicago Title does it, but they themselves admit, go get the real ones from the sellers because we don't know if we have an amendment that we don't have. But when I'm trying to get a purchase agreement put together, sometimes it can just be pulling teeth to get the agent to give it to me. And quite honestly, we were trying to figure this out, whether or not who's the person that's going to be responsible for getting the correct ones, because there is what they tell us. I don't want to be the buyer's agent trying to go find what we should, but I will, because I don't want somebody just handing me some that may be the incorrect ones. I'm going to make sure they're correct.
So the interesting part about that is like, and we talked about this beforehand, is, you know, it's hard when as an agent, and I'm saying we, because technically per the contracts, it is on the seller to give me those documents, and then I provide them, and then it is actually on the buyer, not the buyer's agent, to verify that it's the most up to date, actually, right? And I don't know what, when we were talking to you about it, you're like, that's interesting, because it's a constant like shuffling of who it like falls on, and ultimately it falls on the buyer and their due diligence, and it is slightly removed based on the contract, and not even slightly, it has removed a lot of the liability and onus on the agents in particular, probably due to litigation and lawsuits and all this other thing, as to who is responsible at the end of the day for this. And so like my seller has to give them to me, I kick them over, buyer's agent kicks it to the buyer has to do their due diligence on the back end in a very short time frame, by the way.
Right,
and
right.
HOAs are not always as responsive as they would need to be in a transaction, because like they're people with jobs, and like they're doing this thing for free, and like they may not even see it till 7 o'clock at night, and then they have to do stuff like.
Well, and I think the key there is that I think the existing law is the seller needs to provide it. And so I think there needs to be some mechanism or procedure where the seller's agent has a way to get those documents as you're setting up a listing, that all of those are in place. One thing I always will look at in a sale transaction is when title is pulled on a property, the title company should, if they're running the proper title, it should say every single recorded document. So if you have a declaration that was recorded in 1971, and then there was an amended and restated declaration in 2004, or any subsequent amendments, all of those should be showing up on the title report. So I would use that as a buyer's,
It's the
agent.
timeline, though. By the time they've done
Well,
that, our
yes,
purchase agreement is
yes.
out of timeline to receive those. And it would be nice then if you're saying that we could have something on the purchase agreement states, or if findings have come up after
Yes.
that we have received more
You'd have to add
amendments.
language in there or something like that,
Yeah.
because I mean I get agents who like want
Send you to
changes.
Chicago Title?
No, they
Go
want,
get them at Chicago Title.
They want changes in purchase agreements over some crazy things with timelines where I'm just like, all right, whatever. So because I'll send it over and I'm like, based on this house, I think it'll take this long, and like that's just not how we usually do it on a normal transaction, but I need something longer this time or whatever, and they'll buck back, right? And so if I send over a PA, a purchase agreement, with like a 14-day turnaround on HOA docs.
Yeah.
Like I don't see another agent like.
Well, and like I said, I get a hold of them before I list them, and they're actually in the listing, because if we are in multiple offers, I want to get rid of that contingency. Read them before you even submit the purchase agreement, because it's gone. But I had a question for you, and I wanted to know how normal this is, because we do this, right? In 5 days, we've decided we're going to accept these conditions, move in. I got a phone call from my buyers. They'd lived there for 4 years, and they bought a pickup truck. Their family pickup truck. And he called me. He goes, I have a violation from my HOA stating I can't have a pickup truck in my driveway. And I said, is it a work truck? It has like wording on it. Is it really big, huge tires? He goes, no pickup trucks in the driveway. And I said, it's in Carmel. I said, I would
Dude,
never.
do you know how much, as somebody who owns a pickup truck, do you know how much a nice truck costs?
No, that it was.
I mean, like
kept
80
saying,
to 110
I had so
K
many
on the
questions
truck.
of what kind of pickup truck do you have, and so that was part of the covenants. First of all, he didn't have that truck when we bought it, so we didn't know to look for it. But second of all, how many HOAs say no pickup trucks in their driveway? Like regular pickup trucks.
I don't know that I've seen a lot specifically. It's usually more no vehicles in the driveway. I haven't seen a lot of them distinguished. But this is
No
real
vehicles in the driveway?
Yeah, overnight. So at some associations, you actually have to have the vehicles parked in the driveway.
I have a 3-car garage that I have 0 cars in. Yeah, I mean,
Yeah.
seriously.
Or if you have 4 drivers because of your kids and everything
That's what
else.
I mean. Yeah.
Like how some of these covenants, like I'm going to ask you that. Some of these covenants have carried on traditions from the 1960s and 70s that just need to come out.
Is there anything?
Yeah, but the problem that we're seeing in communities are a lot of the boards are in agreement with that. A lot of the owners are in agreement. But to get the requisite votes, to get that 67% or
Yeah.
7, imagine if you're one of those 1,000-lot communities. But this
And you have
has,
to get a quorum and
yeah,
all this
oh,
other
yeah.
thing.
And I've been very involved. There's an organization called Community Associations Institute. It's national. I'm
that
on
sounds
the board.
fun.
Yeah, I'm on the board, and I'm
Those
the
are
chair of our
fun gatherings.
our legislative action committee, and we propose legislation. So we have done a lot of drafting of legislation to propose to the Indiana legislature to make reasonable changes, things like lowering quorum across the board, because I think people think quorum is that number you need to have a vote, and it's just the number of owners you need to attend to call a meeting.
Correct.
I mean, there are associations who haven't had a legitimate owner meeting in 10 plus years because they can't get
5 people show
60%
up.
of, yeah. So I make a lot of reasonable suggestions, but so far we haven't been
It's
able
hard
to.
because people don't want to go because there's arguing or it's all like
They don't
just
care. I'm not
superficial
involved.
stuff.
I live here. I'm in my house.
Yep.
Don't bother me.
Yeah, and have you ever been involved in one where something within the HOA covenants was considered too restrictive and like not allowed? So like I know a neighborhood, it's a very nice neighborhood, and I've always I understand it. I think it's kind of neat, but like you're not allowed to mow your yard on the weekends.
Oh yeah, that actually,
Excuse me?
yeah, or
Yeah,
Sundays.
well, because it's like
of
a
the
really
noise.
nice
Yeah.
neighborhood, and it's like, like if you can afford to live here.
But if
you're
it's a
paying
really nice
people during the
neighborhood,
week.
they're probably
No.
working during the week.
Yeah, and they want to enjoy their outdoor
Yeah,
time.
like
on
no
Wow.
landscaping on the
Yeah.
weekends.
Yeah.
Like oh yeah.
Laurelwood does
Yeah.
that. Yeah.
Yeah.
And I think it's kind of neat. It was the first time I'd ever heard it, and I was like, that's kind of neat. It also makes sense, but
Well,
like,
the
what if
thing-
you're the
oh
guy
my
who does like to mow your yard?
Right. Well, and that this is the interesting thing about community living. Community living is not for everyone.
No, it's
And
not.
we know those people who it's not for. You know, they're the ones who are constantly in a fight with the board. But the beauty, I guess, of the voting procedure is if a super majority of a community says, hey, we like purple houses, we are going to make an amendment to our declaration to allow for purple houses, or to say no pickups in the driveway, your community can decide that. I guess that's the beauty, is you can have two subdivisions or associations side by side, and one allows it and one doesn't. So
Christmas lights down by like
yes, yeah.
Valentine's Day.
Yeah, that fine. I mean, come on. That
Yeah,
it is
yeah.
kind of a funny fine,
The
but
one
still.
that's been really interesting to watch evolve over the last couple of years are the sex offender restrictions, and there's been a lot of
Okay,
debate
tell me about that.
Yeah.
So quite a few associations have amended their declarations to prohibit known sex offenders from residing on the property. And I just had a case about a year and a half ago where, and this kind of dovetails into our argument about, or discussion about, the disclosure element. An association had deliberately amended, it was a standalone amendment to their declaration to prohibit sex offenders. A woman, her husband was convicted. They had to move out of their community, moved into this community, and she claims that she specifically said to her agent, can sex offenders live? And she said the agent said no, there's no restriction. And it was a standalone recorded amendment. So I'm still curious as to
You could
what
ask that
do-
kind of question. You better find out
I
somebody
was
who
gonna
knows
say,
the answer.
If I could say anything to agents, it's don't guess and definitely don't make up an answer. But
Yeah.
so they sent a violation, and she ultimately had to move. And
They do make them move. So, I mean, there's just stuff like that is those, and I said this, somebody told me how to do this and I haven't figured it out, but they are sometimes 60 pages long, and then you get the next one that's 30. And I want to dovetail into, you said the difference between covenants and bylaws. But the Chat GPT, supposedly I had somebody tell me this, that if you tell them you put it into Chat GPT and you ask it, can there be rentals? You can give it all of that documents, and it'll take you right to the line that says yes or no.
I wouldn't trust it.
So-
On a 1% chance it missed
But if
it.
it takes you right to the section of
yeah,
the
as
page.
long as it just sort of Control F's, sort of takes you to
but
the right spot.
at least those are so long, it's hard to find those kind of things. But
if you're
thought,
used to reading them all day long, I will
I'm
say
not.
we
You know
used
the
to,
section it's in.
Yeah, but I will say the one problem too about Indiana, I think the newer declarations are better. But the problem is there's not a lot of uniformity. So
No.
you've got people putting things in bylaws that should be in the declaration, the covenants and restrictions, they're all over the place. So a lot of what we'll do these like maintenance responsibility charts. And it's a nice chart for an association to see, okay, who's responsible for what? Is this an owner responsible? So that way people don't have to go digging. So
No, sometimes it's just you don't know.
Yeah.
As a homeowner, but can you please exchange the difference between covenants,
Okay,
bylaws,
so,
and
sure.
all of
So-
those?
Restrictions,
So when an
CCRs.
association is created, the developer will record the plat, which will confirm the community and what's common property and owner property, and then they will record the articles of incorporation, which sets up the entity, and then they record the declaration. So the declarations are required to be recorded, which is why no one should ever have a hard time getting these documents in theory because they're publicly recorded. The declaration sets up the community. It defines the property, which is common property, what is owner property, who's responsible for what, and it sets forth the covenants, easements, and restrictions. So that's why they're called a lot of times CC&Rs, covenants, conditions, and restrictions. The bylaws are not required to be recorded, and they usually are more focused on the administration, like the setup of the corporate entity. So how many members can be on the board of directors? Is it 3 members? Is it 5 members? When are you going to hold an annual meeting? The requirement.
Subcommittees, all of that
Yeah,
stuff.
all of that.
Yeah.
So it's more of the administration. So that's why if I see things like covenants in there, we move them to the declaration because the bylaws really is just it's really more administration.
So as a real estate agent, what it was interesting when I heard her say that previously, I'm looking for, when they tell me I'm looking for the CCRs, right?
I'm looking for the bylaws.
Should I also look at the bylaws as well?
I think so
That's
because
the
you
thing.
never know. You could see a
And then there's extra amendments above and beyond that to any
Yeah.
of those. So I know a lot of people, I've just really, when you said that, I just thought it was very important for agents to understand it's not one document. There could be 5 or 6. I specifically have a listing up right now. I've got 6 attachments between all of what they have. So one may not cover what you're looking for.
Yep. You've always got to look at the amendments.
It's so weird too, like that like they don't have power, but they do have power. Kind of weird that like I mean I dealt with a condo last year, and they were just jacking the fees up left and right.
Yeah.
I mean they like doubled it.
How do they limit that over? Yeah.
Like I almost feel like there should be, but then you have special assessments, especially since everything that happened in Miami a couple of years ago, where special assessments weren't being paid attention to, and all of a sudden there's a loss of life, and now
That
everybody.
has been the Champlain Surfside collapse has
Yeah.
been just a huge change in our industry with new focus on associations getting reserve studies, funding reserves in an association, which incidentally in Indiana there is no law on funding for reserves. So I think we're particularly more concerned about it when we're talking about a high-rise building.
Yeah.
If you're in a condominium association, you absolutely are going to want to make sure you've got reserves.
And that's so funny. I've started a long time ago with buyers asking me, the more anal men, it would always be the men, wanted to see the financials. And I'm like, okay, he wants to see the financials. I took that as he's just anal, wants to see, that. But it's important.
Yep.
The amount of times I've had
Super
people come
matters.
back to us and say, oh, there's no money.
Yeah.
Or that turns you into the next question of, oh, yeah, you have a $1,000 assessment coming next year.
Or
$1,000
you
a
haven't
month.
raised, I will tell you this, as an attorney, biggest red flag to me are associations who don't increase their annual HOA. And I see a lot of boards kind of say, they're patting themselves on the back saying, well, we're doing a great job. We haven't raised the association fees. Everything has gone up. Inflation, insurance, every cost has
Especially
gone
insurance.
up. So if you're not just incrementally, even if you don't have a compelling reason for that year, you might want to consider as boards, increasing those.
But that's not how it's seen as a homeowner. It's like, oh, they're just trying to jack our rates up so
I know.
Bonnie can have more money. Like when I was on mine, I was like 28, right? Like I was like, yeah,
You're like,
sure,
yeah,
I'll
how
set-
would you even know what a homeownership means, right?
Yeah, it was horrible. But I remember looking at our financials, and we had $80K for just snow removal, and I was like, that seems a lot. And then
The winter hits.
yeah, then the winter
you're
hits,
like,
right?
yep.
And then you roll it, and then so 1 year it wasn't that bad, and so we rolled 40,000 into the next year, and we had we used all of it and then some the next year because we
yeah.
had that really heavy snowstorm where we had when was this? This is probably 2008, 2010, something like that. Remember when we had that ice storm? in February or whatever, and it was snow, then ice, and then like they cleared the
Well,
roads.
the city
and it was
ran
ice
out of
again.
salt, you
Yeah.
know, like that's happening.
But you have to have that, otherwise, like the money has to come from somewhere, or you don't have roads, or you don't have cleared roads. So.
Well, it's not just, that's why I kind of get to the fact that it's not just asking for the covenants and restrictions. There's more you need to really dive into, whether it's a condo or not. I know we had a listing, and as a listing agent, you really need to have this information up front to know what you're listing. We had a listing where we had a condo downtown Indianapolis, and found out the HOA had not been paying the insurance.
Oh, that's bad.
And
Yikes.
there was no, I mean,
She's
so,
like, yikes.
and it had been a problem that they were trying to figure out, and then they couldn't get an insurance company to come on board now. And those are just the kind of things that'll stop you from even being able to sell. But to get to the closing, I mean, nobody finding this out, and then you purchase a property. So asking for financials, but also just asking if there's going to be an assessment coming up. My two questions when I list a property is, are there any assessments coming up or currently in place, and or are there transfer fees? Because some of these places charge like $500 for a transfer of the, there's so much more than can I just have the covenants. And that's kind of what is one of the things as an agent, we need to really make sure we're getting all the information we need. Is there anything else you can think of?
I think a lot of times questions we'll get is there pending litigation? So it would be interesting to know, is the association named in a lawsuit for any reason? That is usually, I think, a bigger issue with condo associations. Sometimes there's discovery of defect issues, or maybe, anytime you have potential breach of fiduciary duty type issues, I would want to know going into an association if there might be a special assessment because of legal fees or, some pending dispute. I'm generally interested in who's managing the property. Is it a reputable management company that, focuses on HOA or condo management? But I think the key ones are just looking at the budget, making sure they're setting aside funds, making sure there are funds available if there's an emergency. Those are kind of the key aspects.
So, who do you think it ultimately falls on to verify all of this information?
So the tricky part about it is right now the obligation is on the seller, as it should be. The seller is in the best position selling property to say, here, this is the state of our association. Here's our governing documents. Here's, everything you need to know about the community. The problem is we really don't often find out there's a problem until long after the closing has occurred. And then that becomes an issue. An owner can't really come to the association and say, I didn't realize I wasn't allowed to paint the house this color gray, when there's a recorded document or ARC provisions that say otherwise. So now it's kind of an owner-to-owner dispute, the buyer against the old seller. So
Well, and I came into
And then
that.
it's case by case.
yeah.
So what you're talking about is a seller not knowing is
Not
whether or
knowing
not
is
they
not
know.
a sufficient answer. Though,
correct,
right?
but they don't. So I have a specific issue that I have with a buyer who, again, this is where I think there's more question to ask. And then, do you have the covenants for me, please? Is my buyers got a notice from the HOA 60 days after they moved in. Do you know there's still a violation against this house? And it was because they built a outdoor fireplace pizza oven type thing, and it wasn't allowed. The sellers knew it, but didn't let us know it.
Did the buyer or the title company not
Nobody
ask
ever
for...
was given any of that information until 60 days after they purchased it. So again, there's the last final question is, are there any current litigations, fines, or anything against a specific house?
So if someone, typically, my office is contacted for if the title company, again, I think they run that search and they see that there's pending litigation, maybe it's a covenant violation matter, they will reach out to our office and ask for a payoff letter, and we will advise if there's any outstanding assessments and if there are any pending litigation matters and the amount of the fees and what the violation is. What I haven't really been able to figure out in Indiana is why that's not happening on every transaction. So, in other states, there are specific disclosure laws that people don't close on condos or homeowner association type properties unless and until they've got a payoff letter statement from the association declaring there are no past due assessments and there are no violations. So
Correct.
I would always ask for that statement.
What's the responsibility of me as an agent if I'm aware of a violation and I'm not involved in something?
that would get
my microphone's
to.
wobbling. That's weird.
I don't know if I'm as familiar with all of the laws related to real estate agents.
I'll ask you after.
Yeah.
Okay, so
I'm not trying to dig a hole or
the
do
reason
nothing here.
that whole conversation too for me is I have a house that is they have a violation and he's fixing it, but the HOA sent me the letter like within a week of it being listed and said, do you know that this currently has a problem, a violation on it, which I did, and it's supposed to be fixed by closing, and we had, whatever. I was on it already. But that's what an HOA, I think, definitely needs to be doing before these are transferring. Because
If they find out, a lot of them do. For example, at any time, most of the clients that we work with, if they get rumblings of a sale, they will ask us to send a letter to the title company, especially when we're getting that payoff request. But again, I think a lot of times sales are happening and the association doesn't know about it.
They don't know about- or like, when it's a builder still has the HOA, like they're not out there, like.
All right. So going back to that other comment I made about developers are in the business of selling property. They're not out there, issuing tons of violation notices and trying to crack down. They want to sell property. So that has been a big problem.
Because then it's like, does this exist? And so does this change? And then it impacts a lot of people who followed the same direction without an approval, right? Or do you set a precedent that it's now allowed?
Well, and
that's
I
up
have a
to
lot
the
of
new
boards
HOA
dealing
board.
with that, right? That very issue, like a big issue is sheds. You have some associations where it says you cannot have a shed. Well, person A went to the developer, then person B went to the developer, and now you've got 7 sheds.
Because the developer said yes?
Yes, and now
Or patio's
you've got
not past the
board.
edge and stuff.
And now the board is saying, nope, we're not allowing it. And they're like, but all these other people have it. So, and it just, as an attorney, you hate these cases because it's just not clean. I like to be able to go into court and show our board is reasonable. But again, that goes back to that other comment that I made about the best way when a new board takes over is to just kind of sit down and regroup and say, hey, the old board wasn't doing what they needed to do, or the developer, and again, making it clear, we will be enforcing the governing documents.
So that was my next question you were talking about, when the developer is not really keeping their eye on things and or allowing and saying they will allow certain things to happen. Once the board takes over, architectural review has to start. Supposedly it had been going on. So me as a homeowner, if I have something I want to do that Joe did across the street and I love what he did, was against it, but then I say I'm going to do it too, I don't have a precedence that says, oh, I can do it now because you allowed that person. You're saying that at some point it can just draw a line in the sand and say we're not allowing that anymore?
Well, it all is going to come down to what's in the governing documents or in the ARC guidelines. So,
because most likely it wasn't allowed and it just happened.
Or if you could find a document that said
Yes.
they were okayed, or they were properly went through the channels and they said yes, and now I properly go through the channels and they say no. It's like,
and those are the most difficult cases. But when the developer in writing approves something that's clearly against the governing documents, and it's very, very frustrating for associations to take over after the developer has done it.
That's very hard to start enforcing backwards.
Yep.
Yeah.
I mean, we just went through a bunch of it, and there's an interesting one. So, my neighborhood, when you first built, your air conditioner had to be on the backside of the house because Fisher Homes believed that it was. You had to own the noise of your own house, right? And it was like right by these massive bay windows that we had and all this other stuff. And then we were like, hey, can we move it to the side of the house? They were just hard and fast. Like, nope, that's not how we do it. That's not how we do it. 2 years later, like all of the air conditioner units are on the side of the house. You know what I mean? And so everything else we got approved, but I moved my AC unit to the side of my house. I didn't even ask. If they want to come back at me, fine. I don't care. I'll put myself out there. I will, dude. I can care less.
Letter today.
I hope somebody comes at me about it. But I was like, you already set a precedent at this point where everybody has moved it to the side of the house without any kind of board of approval, because that's just how the houses are being built now, right? And it's never actually documented. It was all verbally done in the
Well,
first
this is
place.
exactly what happens with HOAs. Is
Exactly.
he got to, and I'm going to do it too.
Well, here's the thing.
And then it
the
snowballs.
builders-
Yes.
So the builder still was managing the HOA at the time, and then they're like, oh yeah, let's just do it this way, and they just started doing it because it was nowhere.
didn't change the
It was
bylaws?
nowhere in the covenants. It was within the design build of the houses, right? And so like we were like, do we move it or do we not move? Like we were going to move it no matter what. I was like, does this need to be part of what we're asking to be done? And so like we did a pool, we did a screen-in patio, shingles match. Like we did everything the way they wanted to do. And the only thing I didn't ask for permission for was that, because I'm like literally like I'm one of like 10 houses that has it in the back.
Out
and
of
it
400.
wasn't. Yeah. Oh yeah, it was ridiculous. But like little things like that just change. And it's weird. But like our process was, it was difficult to get started. Once it got started, it was very easy. I think that's the thing. People think it's going to be a bigger headache than it really is. Yeah. And even then they're like, hey, we need a little bit better design plan. And I'm like, okay, sweet, here you go. And like, it was good in like 5 days, right? Like it just wasn't a big deal. But I think people don't like the idea of asking for permission when most times it's a rubber stamp for the record.
It really is. And I think most associations do run pretty smoothly, especially when you have professional management. And I will tell you, it just because of some of the horror stories I have now seen that we've had to litigate with people doing things and then refusing to ask for permission. I think a lot of boards are actually good with the retroactive approval. Like if someone's legitimate, like I didn't know, or hey, I kind of saw everybody, so shoot.
Change this one thing and you're fine. You know?
And I think a lot of them are pretty decent. But I will tell you, it's the owners who just dig their heels in and just... I mean,
it's the Karens.
Yes, and the antagonism, and that is really what makes things just kind of snowball. So.
Karens and the Todds. The guys, I think they should be called Todds, because the Todds are the ones with like the trailer out front, and then the Karens are the dandelion police. Right?
Well, I have a question for you. So, talking about needing new assessments because you know the whole financials of the neighborhood. So, if you have to continually sue your own people, the financials are going to start to change, I would assume, because the money that's being used to sue your own people is coming from the financials of the HOA fees that have been poured into it, will cause your HOA fees to start going up because you're
yes
just...
and no.
Okay.
Yeah,
and that is a great question.
Because if they lose, then the fees are usually paid by
the homeowners,
the defendant, I would think.
That's my curiosity.
Yeah, so, and I will say this, at least with the cases that we bring, there's not really a high loss rate because we're only bringing cases that there's evidence to support it. We know we've sent the proper notices. The cases that concern me is when, the association kind of just tried to do it on their own, and then it's like, hey, can you now take this case? But the association pays the legal fees initially up front, but then they do get assessed to the owner.
So the homeowner has to pay those fees.
Yeah.
So,
and I think, over the years, people have talked about, the assessment of legal fees and, is it fair to the owner? And I think there's much to be said for the position. If you have 95 people in a 100-lot association and 95 people are complying with the governing documents, they get their ARC request, they're not doing anything antagonistic, and then you have 5 people who are violating, why should the other 95 pay?
And that's what I think is a common concern or a thought, that is exactly what happens is you go after the homeowner, we're all paying for that because you had to have legal fees.
But that's what's odd is like you paid for it last year in your dues, right? And like even then it'll get reimbursed because it is what
or
it is.
Makes the dues go up is what people think.
It's also on the neighbor because the neighbor has the right to just comply. And so, like, it's not just on the HOA, it's also on the defendant, so to speak, that is choosing to fight it for whatever reason instead of complying. And so I would also argue that the neighbor is also bilking those funds and will ultimately be on the hook for it if the case wins.
And they are. And again, that just goes back to, it just comes down to reasonableness. If an owner...
We don't have any of that anymore.
I know. It's like, these owners, if they just were,
common sense.
If you get a violation letter... just reach out to the board. We in Indiana, we have a grievance resolution process where you automatically, by law, have the right to have a settlement meeting with the board. And I think 95% of the times those meetings are done, an agreement is reached out, the case never goes any further. But it's the ones who ignore it or kind of, thumb their nose at the board and just say absolutely not. And then it just snowballs from there. And I don't know why people want to pay legal fees.
Well, there's nothing like sitting across the table from your neighbors,
arguing
about whether or not I did something wrong. And, you're just like me. You're telling me what to do. I think that it is hard. Like you said, I wouldn't want to be on a board. It'd be so difficult for me.
I'll never do it again.
And the people that do, we had 9 people run for our 5 I think it was 9 for 5 seats. So,
the way to make it easier, people always say, what's sort of the best practice for board members? And I always say, if you have just very clear enforcement policies, whether it's collections or enforcement, that really then takes the personal burden off the board members because, your neighbor comes over to you, hey, we got the letter. This is, don't be a jerk. Why do you have to come after me? And you say, look, we adopted a policy at the beginning of the year. I'm just one of 9 people or 7 people. And I individually can't go against our association policy. And I think just being very clear and uniform and consistent on enforcement, I think that resolves a lot of issues. Because then people also know.
Which gets back to you can't going backwards is impossible. Yes. So stay strong from the beginning.
It's just about communication. And here's the other thing. HOAs do a ton of good. My HOA, I mean, we have taco trucks and crap and Kona ice and movies out by the pool. And
that's a social committee.
But it's part of all of it. Yeah. You know what I mean? And I don't know. And
people
it's
forget
so
the
thankless.
HOA. It's the owners. There's no entity the HOA is the owners. So.
And you're usually just I'm the idiot who signed up for something that has to come tell you something bad. I'm just a guy who said yes.
Just a messenger.
Yeah, man.
Yeah.
So we are going to run out of time just to get to the stats. Anything else you want to say that we haven't talked about do you think would be really important, especially as agents are listening?
I think certainly as agents, the best thing you all can do is just stay really educated, kind of keep on top of what's going on in the HOA condo world. Certainly we're all talking about rental caps and just being aware of any resources that you have available to things like get documents, get information. I have agents who reach out to me if they'll call and say, hey, do you represent this association? Can we get a copy of the documents? Do you happen to know, is there a rental restriction? I will always take those calls. Mm-hmm. So, just being aware of what other resources are.
And what HOAs do you oversee? Right?
We're just going to open up the phone lines for you. But I do want to announce, though, that last night Carmel did pass the law that they are going to go to a 10% rental cap for the city. So that was last night.
I live in McCordsville, so
I know you don't have anything to say. I know.
I have an opinion on
it.
Done. I'm not here.
Well, we're going into stats. It's okay.
Anybody wants to talk to me about it, I'll talk about it. I can see, and we talked about this. Right, wrong, or indifferent. I can understand the argument from both sides, and then it becomes a personal preference and personal opinion on where you feel. That's just kind of where it is,
Well, we talked about it too. If we're talking about the HOAs, when all the HOAs were trying to get their rental caps of the 10%, needing 67 or 75%, they couldn't do it.
Yep.
Which tells me that most homeowners don't want it. So that's all I'm going to say. Let's go to stats.
No, I agree. All right, stats. So we haven't been here in 2 weeks because I was we had stuff.
Yeah. It was race weekend and all kinds of stuff. But go ahead, tell yours.
Okay, so the stats are, I don't know. I mean, I'm going to go into them and I'm going to say there's a little trend going on here that is slightly noticeable in the stats. But as somebody who is in the marketplace, I think it is currently a larger trend than I want to see as we come out of this first week of holiday or summer break and everything, because last year we got really slow around this time. Well, June was our largest transaction month, right, as a state, but I just see some odd trends going on right now. But we also had a very busy third quarter last year, and since we haven't done this in 2 weeks, personal opinion, I've got a ton of houses out there across all the all price points. I mean, the market has really shifted. I read some stuff nationally that said we had twice as many sellers as we do buyers. I was looking at something through Redfin. Locally, it's not twice as many, but there are more sellers than there are buyers, which is, everybody wanted inventory. Mm-hmm. I'm getting inventory.
We've talked about this for the past couple of years. When was the best time to buy? Last week, but now the sellers are sitting a little bit longer, a lot longer, but the main thing is no showings.
It's crazy. And here's what's weird is spring market started really early, right? It started day after Valentine's Day this year, and then it was just really, really intense, and then we got Easter, Mother's Day, and it was a little slow there, but it is crickets on showings.
Was the past 3 weeks, you thought. But we also have to know we live in Indianapolis. Right. We had race weekend, but we have the race couple of weeks with everything going on. We have Memorial Day weekend. We have all the people who are graduating, have the parties. So the last 2 weeks of May are always kind of quiet. Yes. Mm-hmm. but it's not come back. It's now June, so.
And even then, like when it's busy, like I still see showings. Like, I mean, it is super down,
it's
and
quiet.
rates are up. I get it. And so like, I want agents to know, like, if you're sitting like that, like it's not you, like it's the market. And if you're an agent who has a house that sold really, really quickly, because we have had those as well.
They do happen.
I wouldn't be out there telling your you're going to set yourself up for a very bad situation if you start telling all of your clients that you're going to sell it, because it's going to take time. So in Fishers,
even beautiful homes, like you're saying,
dude, I have
perfect homes are sitting and not getting showings,
and they're not overpriced.
Not overpriced.
Yeah.
There's really what we would say would have been those beautiful 4 days, which we call 0 days.
Yeah.
And they're not. And sellers are starting to call and say, what's going on?
Yeah. So in Fishers, I had 39 go on the market, anywhere from 207 to 2.2 million. 29 are still active, so 10 pended, but 43, that was just within the week. 43 actually pended, which would take us down in inventory, but I have the highest inventory I've had. I have 202 on the market. Average days on market is 21, and the median is 11. And in Noblesville, I had 43 go on the market, anywhere from 225 to 1.75. 34 active, 9 pended, but 35 actually pended. So we actually picked up some inventory there. I have 176 on the market. Average days on market is 32, and the median is 9. And so the part that I think is misleading is stuff is sitting, and it's not even showing as days on market to pinned yet, so it's not impacting this. And if I just go back 4 weeks, right, was the last time we did stats, my stats were 12-4, and I'm at 32-9, right? And so like 9 is still really fast, and 32 is still really fast, but that is a massive swing in 4 weeks of days on market. And I'm seeing it across the board, and it is not house specific whatsoever. You still get the ones that do get some bidding wars and blah, 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 all of that stuff. Like, we all know how those houses work. It's
in
not
2008,
rocket
we still
science.
had bidding wars. It's
Right.
like there's always going to be a market where you're going to have a little bit of everything. It's still going to be happening, but
Yeah, it's odd. It's odd.
You can feel it.
Yes.
That's what we just say.
Yeah.
So in Carmel, 51 hit the market. Only 22 of them pinned. And the reason I say only is we're normally seeing almost 3/4 of them pinned at least, or whatever. A total of 40 pinned of all of those. Average days on market for the past 7 days was 25, and the median was 4, which is
So
the
your
average
median's
is
still low, but
this is where the active numbers is what's showing it. So these are the pendings, and these are the ones that sold. These numbers don't show that feel that we have, or the no showings. In Carmel, 135 sold in the past 30 days. Those average days on market were 25 and 5. Those are up from the last time we did stats. But here's the thing. In Carmel, there are currently 234 homes active. That is so much higher than we've been at. And the active days on market currently right now are 48, and the median's 58, median's 41. So these days on market are kicking up, and they're starting to get even. Like we always say, average and median is usually separated. We're getting ready to get close to 60 days as average days on market in Carmel, with a high amount of inventory that I've seen in a while.
Which is where we were in December.
Yeah. So Westfield, there's 51 hit the market in the past 7 days. 13 of those pended out of 51. 34 total pended. Average days on market 24, median 11. So that's ticking up. The past 30 days, 156 sold with an average days of 30 and the median 10. Those days on market are ticking up. Currently active in Westfield, 165 with the average days on market of 83 and the median of 32. These are where the numbers are showing as houses are sitting.
And I think we really try to pay attention to I'm not knee jerk off of 1 week or anything like that. Like, you and I will talk about stuff week over week that we don't necessarily talk about on here because we don't have enough data, so to speak. But this is significant at this point, and I can't tell you that it won't change in 2 weeks either. I'm not trying to predict.
You said, we saw a big slowdown, and then all of a sudden the last quarter was really busy. So we do this once a week to show what we're feeling every week and what's different. But the past 3 weeks, the CNN article that you brought to my attention is one that if anybody's interested in, we could give that to you. But it was an overall national, and we always like to say we don't want to talk national, we want to talk local. But to me, that was just saying exactly what I'm seeing and feeling here. And other agents are feeling it the same. Everybody is kind of talking about it. Zionsville, 11 hit the market. Only 7 of those pended, and 12 did pin, so we lost inventory. Average days on market, 10 and 3. 51 sold with an average day of 16 and 3. Now we know Zionsville just sells because they have no inventory, but they are up to 72 actives. And those actives sitting on the market currently are sitting at 73 average and 34 median. And the way we talk about these actives, these will become our pendings, and that's where we're going to start to see these numbers start to shoot our average and days market. So if I quickly talk about going backwards, in Zionsville, this week in 2022, we had 20 hit the market. This week it was only 11. 23, 21, and 24, 25. So Zionsville's staying its normal, not enough inventory. Yeah. But if we go back to Carmel, the average or the houses that are hitting the market compared to those years, they're coming in with line with the past 3 or 4 years. So we're not seeing a big dip in loss of inventory. We're not seeing a big gain in inventory. What we're seeing is houses sit.
Yeah. At a time when they usually don't, because it's
June.
When people buy.
Yeah.
And here's the thing. I get where it comes from. I mean, rates are high. Prices are high, cost of living is high with credit card debt and 29% interest rates, and like everything is expensive. And so I don't know what gives in all of it. I don't know if there is an answer. There's a lot of uncertainty and anxiety, obviously, with the economy.
Job loss is really starting to come into play.
I don't want to say like we're going into a recession or we are in a recession or like everything is fine. I'm just not that guy. But I do know like, if you can buy right now, right? Interest rates are high, and you can get 2-1 buy downs, all that other stuff. There's inventory that hasn't been out there. That's just the reality of it. But like, you also got to be smart. Like, is it time to buy or is it not time to buy? Like we've gotten out of this buying out of luxury, which is very, very good, and people buy out of necessity, and that's how it's usually supposed to be. I just don't want everybody to be afraid one way or the other, but be responsible.
Well, that's what I was going to say. Here's the 2 things we have been really trying to say a lot is for agents. Number 1, please stop posting on your Facebook that you sold it in one day. Just it sets a feeling out there that this market should go extremely fast. We've talked about that a lot. So anyway, that those posts are hurting the sellers that are out there right now, and the buyers also.
It's scaring the buyers.
It's scaring everybody. Yeah. The second part of that is if you are a agent getting ready to list a house, please know the numbers and the stats for your area, and don't tell your seller it's going to sell in a couple of days because your neighbor down the street did. The market has changed.
Yeah,
so
it has.
that's
and hopefully it changes back. But honestly, though,
constant.
for buyers, I like this. I like that buyers have leverage.
Inventory.
I like that they have options. I like that they can go look at a house a second time and a third time. Like, this is what we want.
Do you really?
I do. Because when people buy impulsively, I'm the guy dealing with it in 6 months anyways.
Yep. Yeah.
So,
no, it's true.
I try not to let
it's just sellers need to have expectations told to them up front in today's market.
Yeah. And I want people to feel okay and calm and know that they're not alone. That's my bigger thing, right?
Yeah.
And because you are going to get questions from your sellers, and you need to know that they are not alone either.
Yeah.
So, and the house can be great, and you're
right. And just showing that, you're not alone. And you may have to start learning how to pull up stats like this to show them exactly why their house is not an anomaly. And unfortunately, we've talked about this before. Our new showing service does not show us the showing stats to tell us how many listings are what they're getting. So that would be a great stat. And I think my board's trying to work on that.
Shoot, mine was not even working while I was out of town. It was just giving me error messages, and I called them. They're like, "Yeah, we know what's going on." I was like, "Okay, that's it. Like, we'll get back with you." Nobody ever called me back. I was like, "What is going on, dude?" That's why I have a team, so they can run stuff while I'm out of town. So
your trip looked awesome.
It was nice. It was very, very nice. So
looked beautiful.
Anyways, I'm Kyle Morris with Morris Property Group and FC Tucker. My number is 317-649-5122.
And I'm Shelly Walters with the Shelly Walters Realty Group and FC Tucker. My phone number is 317-201-2601. And thank you so much, Kelly. Give us your information if anybody wants to.
Do you want to give it out? That's the question.
Yeah, you can just give us your name and the not the brokerage, the law firm you work with.
It's Kelly Elmore with Kovich, Schifrin, Nesbitt, or KSN Law. A lot simpler to say.
That is much easier.
I always say
that's why I didn't say it.
Just call Kelly at KSN.
There you go. Good. Well,
hashtag.
Thank you so much. So much information and
very,
probably
very
a lot
much.
more to know. We really appreciate it.
Absolutely. Thanks for having me.
Thank you.